Good afternoon, everyone, and thank you for joining us today. I'm Claudia Desjardins-Bellil. I'm the managing partner of Miller Thomson Montreal office, and I'm also the head of the National Labor and Employment Group. We're looking forward to hosting you this afternoon. We've got a wide variety of topics we're covering related to legal trends and hope they will be as helpful to you as they are to us. Quick note, the Q&A widget is live, and due to timing of this session, we'll answer any questions you have after the fact and connect with you via emails. It's my pleasure to host this fireside chat on one of the most important and fast-moving topics for employers today, the use of artificial intelligence in the workplace. I'm joined by two fantastic speakers, David Krebs, a partner in Miller Thomson, and the national leader of the firm's privacy, data governance, and cybersecurity practice, who's been advising employers on AI-related risks and opportunities. I'm also joined today by Eleni Tsatumas, VP Legal at Psycho Bunny, bringing an in-house counsel perspective on how businesses are grappling with AI adoption in real time. We'll spend the next 25 minutes exploring some practical questions: what AI systems should employers avoid, what risks arise when employees use AI in producing external deliverables, for example, and how are AI obligations being reflected in commercial agreements. Our goal today is to share clear, actionable takeaways for employers with concrete examples and best practices. As a labor and employment lawyer, I'm struck by how quickly the legal landscape is shifting nowadays. 10 years ago, the focus was on email and social media policies, and today it's AI. I've never thought today the pace changes is quite thinner. Employers face pressure on multiple fronts. Compliance, for example, they need to ensure AI use doesn't breach privacy and employment laws. Culture, and deliverables. What this means is that AI, it's a workplace governance issue. The decisions employers, but also their employee relationships and market reputation. So it's crucial. So my first question, big question for you guys, where do we draw the line between innovative and unlawful AI use in the workplace? Oh, Eleni, so I said my first big question is, where do we draw the line between innovative and unlawful use of AI in the workplace? If you could provide your perspective, that would be great.
Thanks, Claudia. And yeah, it was frozen a little bit. That's why the lag on my end. But like you mentioned, I don't think any of us really imagined how the use of AI would be applicable in the workforce today. I do think when we use AI in the workplace, it is a fine balance between being innovative and unlawful. We need to be mindful that, there's a certain extent to which we can rely on AI. I think it is safe to think of AI as like a tool that we will use to curate certain content. The AI should be used more or less to by the employee to more or less for the employee to carefully select and organize and present certain information that they've been able to curate, as I said. There are a lot of risks associated with the employees or anyone using an AI tool for work-related tasks. For instance, if we're going to consider confidential information of the company, such as internal finance data, or in my industry, unreleased product designs, feeding this information into the AI can have it then generate responses for other users outside of the company. And we'd rather use that AI to instead help curate public-facing market trends and figure those things out rather than feed it with our unreleased information or confidential, designs or products coming up. Also, another consideration when you're looking at the innovative use or unlawful use of AI is from an IP perspective, intellectual property perspective. A lot of times you might be tempted, or people may be tempted to prompt AI to think about using something in the style of another brand, or using it to brainstorm style ideas, which again should always have that that a special touch added by the employee where they go through and carefully select and organize and refine the information. So certain things to put in place or things to consider when looking at how to be innovative while lawful, you can put in place maybe a certain policy like to block ChatGPT, for instance. I know that our company, we've taken a clear stance on this just to be mindful of not abusing the use of AI. We've actually blocked ChatGPT, and instead we use our Google Gemini, which is integrated within our Google Workspace. So then any information that our employees or us are populating into the system is going to remain in that secure ecosystem within our Google Workspace and not be used to train a public model, which could then be kind of used by someone outside of our company or of our network. So that's some innovative ways to use the AI, again, like using it to help you and to curate more content that you would need. But when we go on the unlawful side, I think this is where things can get a little bit trickier and more eye-opening for us at the onset of how AI is affecting us in the workplace. We encountered a situation not too long ago where a disgruntled ex-employee basically hid behind AI in an attempt to make a claim against us. Rather than hiring counsel, they chose instead to use AI to prepare the demand letter and all sorts of responses. And hiring our counsel, our specialists to help our defense, we realized that this employee was basing himself on non-applicable legislation, not even relevant in the jurisdiction, not relevant to the situation. And unfortunately, this individual was so reliant on the AI and the AI's opinion that his case was worth like over a six-figure settlement, and settling this ended up costing us at least double the fees that we would typically incur to defend ourselves in certain things. So AI can be used in a way that is also not as innovative as we'd like it to be or helpful as we'd like it to be. So sometimes we always have to be mindful that it's a tool, it's not a substitute, and we should be using it mindfully and more or less responsibly.
Yeah, that's super interesting, Eleni. Thank you for sharing that example with us. That brings one question to my mind. When employers start thinking about strategies when they encounter issues with their employees, they would also need to take into consideration the possibility that the employee would like to use AI to defend themselves. And I think that's an additional component that employers will now have to take into consideration when assessing risk related to a termination of employment, for example. So thanks for sharing that. And now turning to you, David, what is your perspective on the thin line between innovation and unlawful use of AI?
So I was thinking when Eleni was talking about what employers can do, right, in order to manage risk, and I think it is some of the points that you raised, Eleni, were specific also to your industry, right? Those same risks, they exist, but not, the risk level is going to be lower for somebody who's not in the design business, right? Maybe if you're in the healthcare space, it would be different. And so I think one of the problems we're facing right now, and I do think it is a problem, and many would agree, that we don't have an AI specific law in Canada. We tried having one, the Artificial Intelligence and Data Act, which sort of died with when Prime Minister Trudeau prorogued Parliament a little bit earlier, and so it sort of died. And right now we don't know when and if it's going to be resurrected. And so at this point, with very few exceptions, we don't have an AI-specific law. We have privacy laws that apply to the use of AI. We can't forget that. We have, anti-discrimination, human rights laws that apply to the U.S. To the use of AI. We have copyright law, as you'd mentioned before. We don't have anything AI specific. And I guess there's two exceptions. I think at the beginning of 2026, Ontario will have transparency requirements for AI used in job postings. That's a provincial law. And in Quebec, under their Private Sector Privacy Act, there are provisions related to quote unquote automated decision making, which it doesn't mention AI specifically, but obviously when you're using AI, there might be automated decisions. So I think that's relevant. Now, what do we do in the absence of regulation? Well, employers have to figure out a way to manage their risk because we know they exist. They're just not, we don't know exactly how the law wants us to address them. So we do look to the EU, much like the world has done with the GDPR, which was the global sort of privacy law effect in the EU. We do look towards the EU AI Act. It's been passed. It's not really fully enforced yet, but we look to that. And in the EU, they've structured risk according to low risk, high risk, medium risk. There's some special considerations for generative AI and large language models like ChatGPT and Gemini. There are also prohibited systems that are flat out prohibited, some with no exceptions, some with specific exceptions for law enforcement. The military has wider exceptions, and you can argue about that as well. But as an example of a prohibited system is for the employment space or in the workplaces, for example, using AI to recognize emotions and then making decisions on that, for example, in the recruitment process. So while this might be something that is technologically very interesting and might be very helpful even from the employer's perspective, arguably, it is, and in Canada, we don't have a framework for a prohibited system like that. The question is then, would you at this point want to adopt something like that is considered prohibited in the EU and which, in Canada might run afoul privacy law, human rights, and other sort of employment laws? And I think that's the interesting space we're in right now when it comes to managing risk here.
Yeah, definitely, David. And that makes me think about some tool that I've encountered lately with respect to triage of candidacies that employers receive when they receive candidates for a specific position. And with those triage tools, one of the danger is that it might triage the profile of someone in a manner where it's completely illegal or in violation of human rights law, as you said. I can think about some of the Quebec obligations and legal and laws that would be infringed completely by the use of such an AI, where the information that you're feeding AI may create a bias, right? That's very interesting. Thank you for sharing. Now let's move on to our next question, which is related to the trends that we see in commercial agreements that may in return have an impact on your workplace and your workforce. So Elenia, I'd be interested in knowing from an in-house perspective, how are companies addressing AI in their contracts, and what kind of obligation can it create that also stumbles onto the employees and creates in return employee obligations towards their employers?
Yeah, sure. So what we're seeing more and more of slowly, at least on my end, is that more agreements do include AI disclosure provisions where the suppliers must tell us or the clients when AI tools will be used. And that is always starting to trigger interesting conversations with our finance and procurement teams as to, well, could we leverage the fact that we know that there's a lot of AI being used to maybe negotiate better conditions or better pricing. Because if the work is being produced with the help of AI in some instances, it kind of makes that supplier more efficient, able to streamline things, able to synergize and use and have leverage on some of the other tools that they have. So it's interesting from a finance perspective too, not only this new use of AI disclosure provisions and contracts. And then we've also seen some contracts where they will require our consent, the client's consent, before using the AI. And that for us triggers more of a reflection, because we have to really stop and consider, do we trust our supplier to really look at what the AI is producing to make sure there isn't any of these biases that sometimes live within the AI, or the hallucinations or the stereotypes that live in there. So we want to make sure that we trust our supplier that wants us to consent to before the AI being used, that they're actually going to properly do the exercise full to look at how they're going to produce stuff for us with the AI. So, and when I stop to think about it, this concept of the AI disclosure, yes, is new now, well, as times are evolving, but coming from the beauty industry, whenever we would have images of the effects of a product, and if ever those images were ever enhanced, it was very clear in all of our guidelines, there would be a disclosure that, like, the image has been enhanced, or whatever the proper disclosure was. So it's almost as if the same concept is applying, just simply modernized to today's times to apply to AI.
Yeah, and I think it's really important to educate your employees too to that new reality, so that they're aware they must disclose it, right? Now turning to you, David, what's your perspective on that, and what should employers be aware of?
Well, I think we've touched on it already. And just like Eleni's mentioned, I've seen a shift from sort of outright prohibition, you can't use this in contracts, to now more of a disclosure and a notice, as opposed to sort of consent to use AI. Now, here's the tricky bit though. You said, how can we trust the supplier? I think the supplier has to think, okay, how can we trust our employees? Not in a way that that they'll be sneaky about it, but do we have full control? Are our policies implemented? Do we have policies? Do we have procedures? Are they implemented in a way that a design team, for example, or a consulting team is aware of the fact that, okay, you're working on project A. Do you have to tell the project manager, or you have to tell us if you will be using AI? And I think, when you said, Eleni, that certain products might be closed for an employer, and then the ability doesn't exist. But I think sometimes that ability has to exist depending on the context, and then it's a matter of how do you ensure compliance? Because if you're going to, and I think we'll touch upon this in a minute or so, if you are creating deliverables for a client that are meant to then be passed on in terms of their IP rights, if you've used AI in a way that maybe IP rights don't even exist, or even worse, you've somehow created infringing content, you've used infringing content, then all of a sudden you've exposed yourself, and we've seen this in contracts when it comes to IP infringement, uncapped liability. So I think that's a real risk that needs to be managed through policies, procedures, training.
Yeah, definitely. And you're right. That brings me to my next question in terms of what kind of risks do employers face when employees use AI in external deliverables. For example, you've just given the example of IP infringement risk, but do you see any other risks that employers should be mindful of or look out for?
Sure. I think it depends again on the industry. So when we talk about quality risk, I think that's, in our industry, in the legal industry, that's obviously a paramount concern, the famous hallucinations of court cases and that sort of thing. But then when you look at coding, for example, so the way that software is written now, there's been a monumental shift of what Gen AI has done to that industry, and how much easier you can write code, and how it's embedded in those practices. Now, the question there is, well, understandability. So can you actually ensure that you know what the code's doing and how it's been written? How do you even ensure quality? How do you ensure that man and that person in the middle that can still carry that human oversight? I think that's a risk. And then you get into, my favorite topic, which is cybersecurity risk. You may have unknown vulnerabilities that sneak into your code. You may also have you might be borrowing from open source, and a lot of open source software has what's called copyleft licensing, which means your code may no longer be proprietary at all, and has to, you have to disclose the source code. So I think those are some of the risks that are the most prevalent. And of course, not to mention what we've touched on already, creating something that has a biased undertone, and you don't even know it, and you're putting your whole kind of company at risk because what you're producing is discriminatory, for example.
Definitely. And I think education of your employees as employers is crucial when it comes to AI. And part of the education is also to implement policy. So Eleni, from your perspective, from an in-house perspective, what do your policies have with respect to AI, and how do you ensure control when it comes to employee use of AI or impact it may have on your business? What's the message that you send your employees?
Well, for now, as I mentioned earlier, we have put in place a policy limiting certain AI tools and preferring the ones that are in our closed environment to be able to prevent some of these like leakage of confidential information and maybe infringing upon someone else's intellectual property. But I think the policy in general must, whatever the position that an employer is going to take, must be clear. It should say when AI can or cannot be used. If there ever are certain approvals that are needed, like if maybe even like just like a chart of signing authority or a chart of like sign-offs for to the extent of what the product is going to look for and how much of it was used by AI versus not, and making sure that all of the outputs or deliverables are vetted. So just always having that discussion, being transparent, like you said, it ties into the whole educating the employees, because employees need to understand that using AI with or without disclosures always has some part of risk to it.
And that's a big cultural change. We've seen that AI is used more and more, so it's embedded in the culture, and it's a message that employers should ensure their employees understand, right?
Right.
So David and Eleni, before we close, what's one trend or takeaway that you'd like to leave our audience with? Maybe we start with David.
Sure. I mean, it's the use of AI. That's definitely not a fad. I think I'll stick my neck out there and say that it's not a fad. It's like cloud computing is not a fad. That is now how it's done many times, and so we are. I also think that AI specific regulation will have to come. I just do not. I know there's some voices saying, especially in the US, it shouldn't be, but I just don't see how that will not happen. Now, if it will be as restrictive and as monitored as, for example, a healthcare quality system in the healthcare space, I don't know, because and that's why monitoring, I think that's the one thing that I would leave the audience with, is that these things need to be monitored, because your policies, they might have to change because the law changes and says, actually now copyright attaches here, patent laws changed, and this is what an innovator is and this is what's not. So I think keeping a good handle on what's going on is super important.
Eleni, 10 seconds. What's your takeaway?
As David said, AI is here to stay. So I think we need to find a good balance between innovation and compliance.
Great. So I think the message is clear. Employers need to stay ahead of the curve by combining good policies, employee training, and also contractual awareness with their employees. We may not have AI Act yet or an AI Act yet, but it's coming. So be on the lookout for that. Thank you, Eleni and David, for your insights. It was great. And thank you all of us for joining us. To our audience, as the session wraps up, you'll be automatically moved into the lobby and you'll have to choose your next session. Thanks again.